The letter does not look like much. One page, a case number, and a sentence saying you were paid more than you should have been, and that the money will be recovered from your monthly benefits. Here is what that sentence means in dollars. For retirement, survivor, and disability benefits, the standard rate the agency now applies is up to half of your monthly check until the balance is repaid. That is not 10% of the check. That is half of it. That rate has applied to notices sent since April of 2025, and it replaced an even harsher policy announced 2 months earlier, which was to take the entire check. Now here is the part that matters more than the number, and it is the reason I am making this video. That 50% only begins if you do nothing. There are 3 different forms for 3 different situations, and filing the right one in time can stop the withholding before it starts. Most people file the wrong one, or none at all. Welcome back to Social Security Decoded. Today we are going through the overpayment notice line by line because this is the letter that frightens people most and is explained worst. Let me start with what an overpayment actually is, because the word makes it sound like you did something. An overpayment simply means the agency's records now say it sent you more money than the rules allow for some period in the past. It can be 1 month or it can be several years. And here is the part people do not expect. Most overpayments are not caused by anything the beneficiary did wrong. The common causes look like this. Someone was working while receiving disability benefits and reported the work, but the agency did not process it for a long stretch, so payments kept going out at the old amount. A marriage or a divorce changed which benefits somebody was entitled to. A person on survivor benefits reached an age where the rules shifted. Income was estimated for a year, and the real number came in different, or the agency simply made a calculation error, discovered it later, and applied the correction backward. I want that clear before we go further, because the shame around this letter is one of the reasons people do not act on it. You can be completely honest, report everything on time, and still open this envelope. Now the number. For Title II benefits, which is the family of programs that includes retirement, survivors, and disability insurance, the default recovery rate is up to 50% of the monthly payment. That took effect for notices sent from the 25th of April, 2025, under an internal instruction the agency issues to its staff. To understand why 50 is where we landed, you need the 2 months before it. In early March of that year, the agency announced it would go back to withholding 100% of the monthly benefit, meaning the check simply stops until the debt is cleared. That drew immediate objections from legal aid organizations, from members of Congress, and from former officials of the agency itself on the grounds that people would lose housing. In April, the agency pulled that back and set the default at half. Now, a separate program with a separate rule. Supplemental Security Income, which people call SSI, is not part of that change. For SSI, the withholding stays at 10% of the monthly payment. If you receive both, and many people do, this distinction matters, so look at which program the notice names. Here is the sentence I most want you to carry out of this video. The 50% is a default, not a verdict. It is what happens automatically if the agency hears nothing back from you. If you respond within the window the letter gives you and ask for a lower rate, or ask them to look at the decision again, or ask for the debt to be forgiven, then the collection does not simply start on schedule. So let us go to the 3 doors, because this is where people go wrong. Door 1 is for when you believe the overpayment is not real or the amount is wrong. Maybe you reported the change and have the receipt. Maybe they counted a month twice. Maybe the earnings figure they used is somebody else's. In that case, what you file is a request for reconsideration on the form numbered 561. You are telling them the decision itself is mistaken and asking a different person to look at it. Door 2 is for when the overpayment is real, but it was not your fault, and paying it back would leave you unable to cover ordinary living costs. That is the waiver request, Form 632. You are not disputing the debt. You are asking for it to be forgiven. And the case you are making has 2 halves, not at fault, and cannot afford it. That form asks for a full picture of your household money, and yes, it is long. Fill it out anyway, and be specific about rent, food, medicine, and utilities. Door 3 is for when you accept the debt, you do not qualify for forgiveness, but half of your check is more than you can survive on. That is the request to change the rate, Form 634. You are proposing a smaller monthly amount based on what you can genuinely pay. People negotiate down to modest monthly figures all the time, and the arrangement is routine. Notice that these are 3 different requests, and mixing them up is the most common mistake I see. If you file a reconsideration when what you really need is a lower payment, you may win nothing and lose weeks. And if you are not sure which one fits, there is no rule against filing more than one. For example, asking for the debt to be forgiven while also asking for a lower rate in case forgiveness is denied. Now, timing. And I am going to be careful here because the exact number of days depends on which request you are making and on the date printed on your own letter. The principle is simple. The letter itself tells you how long you have, and the clock starts from the date on the letter, not the day you opened it. Some deadlines protect your right to appeal at all. A shorter, earlier one protects your money while the appeal is pending, meaning the withholding does not begin while somebody re-examines the case. That is the one people miss, and it is the reason I keep saying to act in the first days rather than the last. So, the first thing to do when the envelope arrives is not to panic and not to pay. It is to find the date on the letter and the deadline paragraph, and write both on your calendar. Let me put some numbers on it, and this is an illustration rather than anybody's real case. Say your monthly benefit is $1,800, and the notice says you were overpaid $9,000. Under the default, up to $900 a month comes out, and at that rate the balance clears in about 10 months. 10 months on $900 a month, when your rent alone is more than that, is not an inconvenience. It is a crisis, and it is exactly the situation the third form exists for. If you propose $50 a month, the same debt takes years, and the agency generally works with people who come forward with a reasonable figure and the paperwork to back it. There is a second question that comes up constantly, and the letter almost never answers it. What happens if you are not receiving a monthly benefit anymore? Maybe the overpayment relates to a disability benefit that ended when you went back to work. Maybe it belongs to a spouse who has died. In that case, there is no check to withhold from, so the debt does not simply evaporate. It moves to other collection routes, and the one people encounter most is having a federal tax refund applied to the balance. Other routes exist as well. I raise it not to frighten anybody, but because it changes the arithmetic of ignoring the letter. If you are still receiving benefits, ignoring it costs you half a check. If you are not, ignoring it can quietly cost you a refund you are counting on next spring. Either way, the response is the same. Answer the letter. Now let me describe the way this usually walks through a household, because the pattern repeats. A woman in her late 60s starts receiving survivor benefits after her husband dies. She reports the death, the funeral home reports it too, and payments adjust. About a year later, she takes a part-time job at a school, 20 hours a week, and she tells the agency. The person she speaks with writes it down. Nothing changes in her deposits, and she assumes that means it did not matter. 14 months after that, the envelope arrives. It says she was overpaid several $1,000s, that the recovery will come out of her monthly benefit, and it names a period she has to go back through her own calendar to make sense of. Notice what actually happened. She did report it. The consequence was processed late. The rules were applied backward to the correct date, which is how the system is built, and the gap between the rule and the paperwork became her debt. That is why the waiver question is written the way it is. It does not ask whether the debt is real. It asks whether you were at fault and whether repaying would leave you short. A person in that story has a genuine answer to both halves, and it is exactly the kind of case the forgiveness form exists for. One more common version. Someone on disability benefits starts working during what the rules treat as a trial period, and the earnings are reported faithfully every month. Because the review takes a long time, benefits keep arriving for many months after the point when the rules say they should have stopped. When the review finally lands, every one of those months is counted backward as an overpayment. The person did nothing but work and report, and still ends up owing. Now, what actually to do, in order? The first step is to read the notice twice, and specifically look for 4 things: which program is named, what period the overpayment covers, the total amount, and the response deadline. If any of those are missing or unclear, that itself is worth a phone call. Second, request your file. You are entitled to see how they calculated the figure, and asking for the payment history often reveals the disagreement in about 10 minutes. Many people who thought the number was arbitrary find a specific month where a report was never processed. Third, choose your door and file. Use the form that matches your situation. Keep a copy of everything and get proof that you filed. If you go into an office, ask for a receipt. If you mail it, use something that shows delivery. Fourth, keep paying attention to your bank account in the following months. If withholding starts anyway while your request is pending, call and say so and reference the date you filed. Administrative systems make mistakes, and yours is not the only case in the pile. Fifth, get free help if this is at all complicated. Legal aid organizations, and in some places the free counseling programs for older adults, handle these cases regularly, and they do not charge. You do not need to become an expert. You need somebody who has seen 100 of these to look at yours for 20 minutes. A word about how to talk to the agency when you call, because tone changes outcomes more than people expect. The person answering the phone did not create your overpayment and cannot forgive it on the call. What they can do is note your file, tell you exactly what was received and when, and record that you have requested something. So the useful call is short and specific. Give the case number, say which request you are filing, ask them to note the date, and ask what else they need. Then ask for the name or identification number of the person you spoke with, and write it down with the date. That single habit has settled more disputes than any argument. If you go to an office in person, bring 2 copies of everything and ask them to stamp yours as received. If you mail it, send it in a way that gives you proof of delivery. The most common preventable loss in this whole process is a form that was genuinely filed and cannot be proved. Let me talk about the emotional part for a moment, because it drives the outcome more than any form does. The reaction I see most often is silence. The letter goes in a drawer. Weeks pass, the deadline goes by, the withholding starts, and only then does the person start making calls, at the point where every option is harder. It is not laziness. It is the very ordinary human wish for a frightening piece of paper to not be real. If that is where you are, or where somebody you love is, the smallest useful step is not to solve it. It is to open the envelope and write 2 dates down. That is all. The date on the letter and the deadline. Everything else follows from those 2 numbers, and most of the panic comes from not knowing them. And one more piece of practical protection. Beware of anybody who contacts you offering to make an overpayment go away for a fee. The agency does not charge for waiver forms. Legal aid does not charge, and a stranger who calls you about a letter you have not told anyone about is not somebody with good news. Let me bring this together. An overpayment notice is a bill from a system, and like most bills from systems, it is negotiable in ways that the letter does not advertise. The default is half of a Title II check and 10% of an SSI payment, but the default only takes effect when nobody answers. 3 forms exist because there are 3 genuinely different situations, and the first job is knowing which one you are in. 3 things to carry with you. The 50% rate is what happens if you do not respond, so respond. The form you need depends on whether the debt is wrong, unfair, or simply unaffordable, and those are 3 different letters, not 1. And every deadline in this process is measured from the date printed on the notice, so find that date before you do anything else. I should say the plain thing. I do not work for the Social Security Administration, and I am not an attorney. Everything here is general information based on the agency's published instructions and on materials from legal aid organizations that handle these cases. Rates and procedures can change, and yours may differ, so read your own notice, call the number printed on it, and get free legal help if the amount is significant. Now, I would like to hear from you. Have you or someone in your family received one of these notices? And what happened after you responded? Did the withholding stop while it was reviewed? Your account of how it actually went is worth more to the next person than any explanation I can give. If this was useful, subscribe. The next one I would send you to is the episode on the earnings test, because working while collecting is one of the most common ways this letter arrives in the first place. I am your host at Social Security Decoded. Know the rule, then decide. not the other way around.